Hi, it's Mike DelSignore. I'm a Boston OUI lawyer. In today's video, I want to talk about the penalties when you're charged with a second offense OUI. In OUI, on the second offense, there's two types of resolutions of these cases, and it depends on how far apart your prior offense. If your two offenses are within 10 years, you're eligible for what's called the Cahill resolution of the case, where you can get back on the road with an interlock device. So if you refused a breathalyzer, and your offenses are outside of 10 years, you have an option to potentially get back on the road earlier. Normally, a refusal on a second offense is a 3-year license loss. So if your two OUIs are within 10 years, that you're going to have to win the case to get back on the road. There's an appeal to the RMV to challenge the refusal. It's highly unlikely to be successful. So for all practical purposes, you got to win your case if your two OUIs are within 10 years, because there's a very stiff penalty for refusing a breath test. However, if they're outside of 10 years, there are other options. Now, if you took a breath test and failed, you only face a 30-day suspension initially. So you can get your full license back in 30 days while we're fighting the case. However, the government's going to have the breath test evidence to use against you. That's going to make their case stronger. But I've won cases routinely with breath test evidence. We can fight, challenge the breath test results to keep them out of evidence. So don't assume you can't win your case even if you failed a breathalyzer. So what do we look for in trying to win an OUI case? I want to find things that show that you're not impaired. I'm going to challenge the driving. Was the driving caused by any other factors? Road conditions, weather conditions. Maybe you just were tired while you were driving. Same with field sobriety tests. Those tests are not easy to perform. There's a lot of reasons why someone may not do perfectly on a field sobriety unrelated to alcohol. So we take the government's evidence and we basically say, hey, you're saying this person is impaired because they missed heel to toe, stepped off the line. But look how they got out of the car. When you weren't testing them, you asked them to get out of the car. They didn't lean on it, use it for balance. The field sobriety, you asked them to do these tests, but they never had a chance to practice. They've never done these tests. Cars are whizzing by. They were nervous. It really wasn't a fair way to evaluate the person, is what we argue. And we point out everything you did right. Most people essentially do the test. And what the officers are criticizing is minor things like, oh, you missed heel to toe, you stepped off the line. Well, there's a lot of opportunities to make mistakes. There's 9 steps up, 9 steps back. So we put all that in perspective and say, hey, when you look at the test as a whole, the person did well. You don't have any major observations of impairment. So I've used that argument many times on the 9-step walk and turn to challenge the assumption that if someone makes a mistake, they're impaired by alcohol. Same with the one-leg stand. You might have knee, back injuries, medical issues. Some people can't do a one-leg stand no matter what the circumstances are. So this test isn't really a great predictor of whether someone's impaired. If you're polite, cooperative, respectful, we can use that to show that you're not impaired. The jury is instructed that you can consider someone's behavior, appearance, demeanor in assessing whether they're under the influence of alcohol. So certainly if you're polite, cooperative, it helps with that argument. Juries are also told they can consider someone's alertness, ability to respond promptly. So I like to bring out to the jury that, hey, when they ask for your license, you provide it right away. When the officer put the blue lights on for you to stop, you responded immediately. So we take all the things you did right and we basically add them up and say, well, this person did too many things right that are inconsistent with someone impaired by alcohol. So these are winnable cases. Don't assume you can't win the case even if you're charged with a second offense. A second offense is still a misdemeanor offense. You can get back on the road. You would have to have an interlock device if you admit to any second offense. So understand the license implications when you're charged with a second offense. It could be if you took a breathalyzer on your first offense that I could go back to that other court. Let's say you had a plea in, say, Somerville District Court, your first OUI, continued to without a finding. If that was between 2011 and 2019, I might be able to go back to that court, undo that case, and now you got a first offense. I've done this a lot for clients. I could say there's like 10 clients in the last year that had second offenses knocked down to first offenses, and many of those clients avoided an OUI on their first offense. So if I can vacate that plea, it could be that case cannot be proven at this time. My name is Mike DelSignore. I help people in Boston fight OUI cases. If you're charged with a second offense or any offense, contact me. Call, text 781-686-5924.